Thursday, 21st day of April 2022, court by Zoom at 2:36 p.m. before the Honorable Justice Sybil Williams, Appellate Jurisdiction 2019, number 29. Jeffrey Stirling versus the Minister of Home Affairs. Mr. Sanderson for the appellant. Mr. Sadler-Bass for the respondent.
Thank you very much, Ms. Aswood. Yes, good afternoon, Ms. Sadler-Bass.
Good afternoon, my lady.
I think that we left off. Good afternoon to me, also Mr. Sanderson.
Good afternoon, lady.
I believe we finished at the conclusion of Mr. Sanderson's submissions, and I'm to hear from you now.
Yes, my lady.
Thank you.
If I may just ask your ladyship to pull up the respondent skeleton arguments.
Yes.
And if I could just ask you to go to paragraph 6.
Yes.
We say here, my lady, the appellant relies heavily on the difference between the definition of lot and of lot size.
Yes.
Alleges that the respondent is wrongly conflating the two for the purposes of determining lot density.
Mm-hmm.
This allegation, we say, is misconceived. The appellant has focused on one aspect of the definition of maximum density and thus ignores the remainder of that definition. Maximum density is defined as the greatest number of dwelling units per acre as may be permitted to be developed on a lot of land. Definition does not refer to the greatest number of dwelling units that the lot can possibly bear or that may fit on the lot of land. And if I may just pause here, my lady, just to harken back to something that arose when we were last before you, it appears that the submission has perhaps led to a mistaken impression that we are saying that may be permitted to be developed depends on some kind of discretion. That's not what's being submitted. Mm-hmm. What we're saying is that it's not an issue of discretion, but that it's a matter of lot size being baked into the consideration of what may be developed. And if I could just ask you to turn to the plan, which is at tab 5 of my friend's authorities bundle.
Yes.
I'm just going to point out a few different sections just to illustrate the point, my lady.
Mm-hmm.
So if you go to page 66.
Yes.
And you would see to the bottom of the page, DSN 18.
I don't see it yet. Where am I looking?
So page 66 of the Bermuda plan.
Yes.
It's headed residential design standard.
Oh, I'm sorry. I'm just looking at a bottom 66. I thought you meant just basically the record. Okay. What tab am I looking at? Just remind me, please.
So this is tab 5 of the appellant's authorities bundle.
Yes, thank you. All right, I'm with you.
Yes. So page 66.
Yes.
And the penultimate paragraph is DSN 18.
Yes.
And it says communal open space shall be provided in any residential development proposing 5 or more dwelling units, and the minimum area shall be equivalent to 10% of the lot size, mm-hmm. and may be provided at or above grade level. If I could just ask you to then go to page 154.
Okay. Yes.
RSD 9A.
Mm-hmm.
So it says a proposal for a detached house may be permitted on a compact lot within a residential 1 zone at the discretion of the board, but only if the board is satisfied that A, the minimum lot size is not less than 3,500 square feet. And if I may just ask you next to go to page 207.
207, yes.
Yes, my lady. At the top, DEF 76 defines lot size minimum means the smallest area for a lot which may be approved for development purposes in a plan of subdivision.
Yes.
Having gone through those, my lady, if we could just go back to what the particular section that the application was made under, or that governs the application, is at page 151.
Yes.
RSD 3.1 says the following forms of residential development may be permitted in those areas designated residential 1 or residential 2 in accordance with the following provisions. We're dealing here, my lady, with residential 2.
Yes.
E says maximum density 6 dwelling units per acre.
Mhm.
Under that, H, apartment house, minimum lot size 18,000 square feet, maximum site coverage 20%. And what we're saying, my lady, is that in every consideration or discussion of what may be developed, it's always in reference to, or it's often in reference, at least in these cases, to lot size. And what may be permitted, RSD 3.1 has that phrase in there, may be permitted, is according to what comes below, which is the lot sizes. So we have 6 dwelling units per acre. Underneath that, we have the stipulations as to lot size and how much of the site coverage is the maximum for the development. So that development, my lady, is now limited to that minimum lot size, 18,000 square feet.
Yes.
And we've seen what lot size is defined at. If we could go to page 206. And that's DEF 75. Means the area of a lot which is calculated by excluding any land used as a road and any land which is used as a right-of-way or easement for vehicular access to 3 lots or more, notwithstanding that the subject lot may not gain its access from that right-of-way or easement. So the starting point in this particular matter, using those parameters, was a lot size of 0.458 acres.
Mm-hmm.
And you'll find that, my lady, if you go to the main bundle, the record,
Yes.
at tab 16, which is the board decision,
Yes.
you see that at page 49 of the bundle.
Yes.
The second paragraph on that page starts: the developable area in this case therefore equates to 0.458 acres.
Mm-hmm.
Application as submitted has been assessed accordingly. With regards to density, this is a residential 2 zoned lot where the maximum density permitted in accordance with Bermuda Plan 2008 planning statement policy RSD 3 is 6 dwelling units per acre. As such, for this 0.458 acre site, the number of units permitted is 2.74 and rounded up to the first whole number, 3 units. The application as submitted seeks final approval for 6 2-bedroom units. This is not in accordance with the maximum density permitted on this site according to policy RSD 3.
Mm-hmm.
Furthermore, site coverage requirements as set out in policy RSD 3 are exceeded. The maximum site coverage for a residential 2 zone is 20%, whereas the application proposes 29% site coverage. This,
This is in the report, yes, the board's report. Thank you.
yes, my lady. And this was a position that was put forward by the Department of Planning. If I could just ask you to go to tab 17.
Mhm.
At page
Yes.
3.
Sorry, did you give me a page number in tab 17?
Page 73.
73, okay, thank you.
Yes, my lady.
Yes,
Paragraph, you see where at the bottom, my lady, it says paragraph 4, appeal case.
mhm,
The appellant states that the board report is referring to the application site and legal subject lot as two different items. The departmental response, to clarify, the board report refers to the application site as being the portion of land available for development. The Bermuda Plan 2008 planning statement, DEF 75, states that lot size means the area of lots, which is calculated by excluding any land used as a road and any land which is used as a right-of-way or easement for vehicular access to 3 lots or more, notwithstanding that the subject lot may not gain its access from that right-of-way or easement. As stated in the planning assessment section of the board report, the Department of Planning received legal advice from the AG's chambers for this application and the prior application for the same site that was withdrawn regarding the definition of lot size and calculating density. The AGC clarified that the size of the lot equates to the total amount of lot which is available for development, and that the various ways and pathways should be excluded when calculating the density of development for the lot. As such, the application has been assessed based on the lot size, excluding the area of the various roadways and pathways, calculated to be 19,950 square feet. That is the 0.458 acres that I took you to in the board report. There was also an argument, I believe, my lady, that the fact that lot size is not calculated by taking out, for example, a conservation zone, should influence or should guide how the lot is determined as it relates to easements and such. And this was dealt with, or at least argued on, in this same statement from the Department of Planning.
okay.
Go to page 75. It starts at the bottom of 74, my lady.
Okay,
If you see the paragraph that says paragraph 5, appeal case, then departmental response.
yes,
Then the second paragraph said, with regard to appellant statements on density calculations for application sites which include conservation zoned land as part of the total lot, the Bermuda Plan confirms, and they go through zone 9.1, which we could come to at a different time, my lady, when we deal with the planning inspector's decision or recommendation. But if you look on page, at the top of page 75,
right,
the argument is that as such, there's flexibility with the plan to allow a conservation-based zone or conservation area to be developed at the discretion of the board. And that last paragraph of that section says conservation-based zones and setbacks can be considered as developable areas, unlike roadways and pathways, which may form part of a lot. This is in accordance with the advice received from AGC, who confirmed that the size of the lot equates to the total amount of the lot, which is available for development, excluding roadways and pathways. Density calculations should be and are made on this basis. And this is not something that was out of left field, my lady, because this was also something that was acknowledged or at least addressed in the initial application by the appellant. And if I may just ask you to go to paragraph 8 of my submissions.
yes. Yes.
We say, it is important to note the board's references to acknowledgements by the appellant's agent. It was clear at the time of the appellant's application that the agent, Bermuda Environmental Consulting Limited, was aware of the relevant consideration as described by the board. BECL, in its letter of 15th May 2008, and for your reference, my lady, that's at tab 1 of the record.
Okay.
Stated, the prior application raised concerns about density for R2 zoning and the policy definition of lot size, with the requirement to exclude roadways and easements used for vehicular access. Rather than dispute the use of lot size as a relevant consideration, BECL advanced instead an argument based on uniqueness of the site. BECL argued that some of the rights of way are not in fact roadways and cannot be used for vehicular access. BECL went on to invite discussion on this point and stressed the argument, potential density issues notwithstanding, that the proposed development as a whole meets the key policy standards and does not create any negative impacts. Of course, the position we can see, my lady, has changed since then, but this was what was understood at the time, and the application was being made on the basis of, as my friend put it last week, this being a very unusual lot. And therefore, the density issues could be overcome or should be overcome, as opposed to there being no density issues. And if I may just ask you then to go to the inspector's recommendation, which is at tab 18.
And which bundle?
Of the record.
Okay. Yes.
If you go to page 83 of the record, my lady, that's where the inspector sets out the appellant's case. And as it relates to this issue, it's only contained in 7.1. In response to the board's decision to refuse the application, the appellant has submitted grounds for appeal dated 11th February 2019, supplemented by additional points made by letter dated 9th May 2019, in response to the Director of Planning's case dated 20th March 2019, that advanced 5 points in appeal of the decision. Briefly, 1, definitional problems with what constitutes the legal lot and how one calculates the net area for density purposes is ambiguous.
It's just occurred to me that I should double check with Ms. Aswood that the court smart is properly picking up the audio. I forgot to make that point at the outset. Ms. Aswood, are you able to just give me a quick confirmation? Let me try just one more time. Ms. Oswood? All right. I think you should continue, Ms. Avila best, but when you just find an appropriate little pause for me to go and just verify that, which I think will take a minute or two, you can let me know.
Well, I'm moving on to the inspector's report now, so that could be.
All right, just give me a moment. It'll literally take 1 or 2 minutes. Thank you.
Thank you, my lady.
Yeah.
All right, I am assured that we are good to continue. Unfortunately, Ms. Aswood has to be at two different locations to somehow manage the live streaming and the Court Smart, so she may not be able to respond immediately, but I am assured we're fine.
Thank you, Madam. I was at paragraph 7.1.
Yes.
Yes. Definitional problems with what constitutes a legal lot and how one calculates net area for density purpose is ambiguous in the policies of Bermuda Plan 2008. The plan is not clear when it comes to how and when lot size / not net lot area is to be applied. The exact language lot size is used in some cases and not in others. It would appear that definitions are applied on an ad hoc basis. The Bermuda Plan is generally permissive in including areas that cannot be developed on, setbacks, conservation areas, other built hard surface areas that may exist on a lot, to nonetheless be included in the lot area for the purposes of calculating density entitlements. So this is the inspector's synopsis of the appellant's case on the issue of density.
Mm-hmm.
I could ask you, my lady, to go to paragraph 9.
Okay.
Which is where he begins his findings. And if you could just start from the last sentence of paragraph 9, this unusually configured lot
Yes.
conforms to the definition of lot set out in chapter 35 of the Bermuda Plan 2008 planning statement as follows. DEF 73 lot means a parcel of land which before 27 June 1974 was held by a single title or which is within a registered plan of subdivision or which is deemed registered in accordance with the Development and Planning Amendment Act 1997. Notwithstanding that the greatest area of Lot 8 is functionally undevelopable, consisting of roadways and easements, the fact remains that Lot 8 in its entirety constitutes a legal lot by the definition of the plan. Why Lot 8 was registered as such an unusually configured parcel is not clear in the documentation contained in the file. The fundamental question upon which this appeal turns is, what area of Lot 8, the entire legal lot area of 1.17 acres asserted by the appellant, or the area of the developable parcel, B, of 0.46 acres, asserted by the Department of Planning, should be used to calculate the maximum density permitted for development on Lot 8. The answer to this question determines the maximum number of dwelling units permitted on the site at the permitted ratio of 6 units per acre in the residential 2 zone. All other matters relevant to this case hinge on the correct answer to this question. The appellant makes the case that the Bermuda Plan 2008 planning statement allows for the calculation of allowable development density on the basis of the area of the legal lot in total, which they term the gross density. In this instance, regardless of whether a legal lot is encumbered by conditions such as roadways, easements, and conservation overlay zones that reduce the developable area to something less than the total area of the legal lot, the density entitlement is calculated on the basis of the area of the legal lot and not a net developable area arrived at by subtracting those non-developable portions. In defense of this position, the appellants point to the plan definition of lot cited above, which clearly states that a lot means a parcel of land held by a single title. And further to DEF 3, I think that should be 73, which states that density maximum means the greatest number of dwelling units per acre, which may be permitted to be developed on a lot of land. By this analysis, Lot 8, which includes 5 separate but contiguous parcels on 1 legal title, with a total area of 1.177 acres, which at the residential 2 zone maximum density rate of 6 dwelling units per acre, would generate a maximum density entitlement for Lot 8 of 7 units. The appellants further point to the practice of clustering permitted density on the developable portion of a lot, with reference to policy guiding the development of lots encumbered by an overlay conservation zone or area. Policies ZON9-1 states, in determining an application for a parcel of land subject to both a development-based zone and a conservation-based zone or conservation area, that the board may permit wherever it is feasible the maximum density of dwelling units or the maximum site coverage prescribed in the applicable base zone policies to be achieved on the basis of the total area of the lot where the board is satisfied that, and it sets out some conditions there, my lady. The appellants argue that this policy provides guidance in this instance as well, insofar as it demonstrates the principle that the plan recognizes that the density entitlement permitted to a lot can be clustered on the developable portion of a lot, and that the landowner is not thereby unfairly penalized simply by virtue of having a conservation-based zone or a conservation area designation on their property. However, I would point out that policy Zone 9.1 does not confer an absolute entitlement to a landowner of the maximum density permitted by the development-based zone. Rather, the policy clearly states that the board may permit wherever it is feasible, which indicates that the determination of maximum possible permissible density on lots so encumbered falls within the board's discretion. Only where all three conditions, A, B, and C, are met to the satisfaction of the board would the maximum density permitted by the development-based zone be recognized. On this basis, I conclude that the Bermuda Plan 2008 planning statement does not absolutely affirm the principle of calculating density on the basis of a total legal lot area, but recognizes circumstances where within the application of the board's discretion, that analysis of conditions on the ground may dictate a lower density entitlement than that arrived at arithmetically on the basis of zone density ratios and legal lot area. So using the entire lot dimensions, my lady, may be permissible, at least in this instance, zone 9.1, where discretion is used to allow it, but not as a starting point. Mm-hmm. And we've already gone through the particular regulations, I suppose, as it relates to this particular area, my lady. And what this boils down to on the appellant's case is, if you have a look at the appellant's submissions, my friend's submissions, paragraph 3.3, I can.
3.3, yes.
Yes. Where it said, if the area were calculated according to the area of the whole lot, this would allow 7 dwelling units. If, however, roads and pathways were to be excluded, it would allow a mere 2 or 3 dwelling units. So what it boils down to, my lady, is the developer's desire to maximize the potential of the lot. But it doesn't change the actual starting point or the regulations that apply. And we see where in certain circumstances, the board could be asked to exercise a discretion. And from the application itself that was submitted by BECL, that was clearly the request that was being intimated. There was an invitation that lot density should be discussed with the parties before there was even a decision made. And so it's clear on the evidence that while there might be some disappointment with the result, this is the position that the Bermuda Plan leaves us with, where the developable area, which is the lot size, is 0.45 something acres. And everything else is calculated using that particular starting point lot size. If I may ask you to go to paragraph 12 of our submissions, my lady.
Yes.
Where we say, the minister expressly stated his acceptance of an agreement with the independent inspector's recommendation. And this is the crux of the minister's decision. If I may just ask you to go to tab 18, that's where we just were, I think, my lady. So the last page of tab 18. On that last page, my lady, you will see that it's signed by Mark Hornell. It's ticked, I agree. It's signed by the minister, dated. That's a different date, my lady. You see that's 11th July 2019. Whereas the recommendation was July 2nd, 2019. And the minister also writes, agree with inspector's recommendation, and initials that. We say in paragraph 12, my lady, that the minister was entitled and is correct to rely on the recommendations or recommendation. And that is taken from Best against Minister of Home Affairs 2017, paragraph 16. And if I could just take you to that case, my lady, it's in our submissions bundle at tab 1.
Sorry, let me just make sure I follow you. I understood Mr. Sanderson to be pointing to the minister's agreement with the recommendation made by the inspector as an inconsistency, having shown me and taken me to portions of the inspector's findings which did not accord with what the minister settled on. Are you?
Yes, my lady. So that is the next submission because we're still on the density issue, but.
Oh, I see. Okay, just in the context of density, that's fine.
Yes.
Okay.
So the density is all that's decided on by the inspector because he's indicated that's all that needs to be decided on.
Right.
And the minister has indicated on the inspector's report itself that he agrees with that recommendation. And I'm just going to the case law that says that he's entitled to do that, my lady. I mean, to the extent that that's really required.
So I'm in your submissions, your bundle? Yes.
So the tab 1 of that bundle.
Yes.
And if you go to paragraph 16, my lady. It's very strange reading my name, but as Mrs. Sadler-Best submitted, it is legally sufficient for the minister to effectively adopt.
Sorry, 1 minute, please. Yes.
Yes. It is legally sufficient for the minister to effectively adopt the inspector's report as the reasons for his decision. And he cites the Southdown Farm Limited against the Minister of Environment. And he says also, if you go to paragraph 14 of that case, my lady, which is on page 4.
Thank you. Yes.
The sentence in the middle that goes, the minister essentially accepted. The minister accepted.
Thank you.
Yes, ma'am. The minister essentially accepted the recommendations of the planning inspector, who is appointed to introduce a level of technical skill and professional independence into an appeal process, which could otherwise easily reflect nothing more than the exercise of raw power, raw political power. We go on in paragraph 13, my lady. While the interpretation of the Bermuda Plan is something that the court can examine, the court should respect the expertise of specialist planning inspectors and start at least from the presumption that they will have understood the policy framework.
Where are you reading from now?
I'm sorry, my lady, paragraph 13 of our submission.
Of your submissions, okay.
Yes, I'm very sorry, my lady.
Yes.
Yeah.
Okay.
While the interpretation of the Bermuda Plan is something that the court can examine, the court should respect the expertise of specialist planning inspectors and start at least from the presumption that they will have understood the policy framework correctly. and that is taken from Wiltshire Council against Secretary of State for Housing, which is in the footnote 14, my lady. The court should have to engage in a painstaking construction of the relevant text. It will seek to draw from the words used the true practical meaning and effect of the policy in its context, bearing in mind that the purpose of planning policy is to achieve reasonably predictable decision-making consistent with the aims of the policymaker. It will look for an interpretation that is straightforward without undue or elaborate exposition. Often it will be entitled to say that the policy simply means what it says and that it is the job of the decision maker to apply it with realism and good sense in the circumstances as they arise, which is what local planning authorities are well used to doing when making the decisions entrusted to them. So we submit at paragraph 14, my lady, that the court should be careful when being asked to overturn the interpretation of policy by the independent specialist inspector and the application of such a policy by the specialist inspector. It is submitted in circumstances that the appellant therefore has a high burden in substantiating this ground of appeal, and we submit that they fail to do so. Paragraph 15 is sort of the beginning of our submissions on the next limb, my lady, which will start to deal with my friend's submission about the inconsistency.
Yes.
Submit here that where the appeal fails on this ground, the entire appeal fails. As the inspector stated, all other matters relevant to this case hinge on the correct answer to this question, which is the density issue. And this finding, my lady, we would say was not challenged in any way, this appeal. And it's in fact relied on. So if we go to paragraph 16 of our submission, actually, if I could go to 17, 16 just restates the ground of appeal.
Yes.
It is submitted that in circumstances where the minister's decision cannot be quashed on the basis of ground A, which is the density issue, my lady, it would best be an academic exercise to entertain the appellant's remaining ground. And if I could just ask you to go to ex parte Delaney, which is at tab 5
Okay.
of our authorities bundle. And if I could just ask you to start at paragraph 4.
Okay. Yes.
It was submitted by the first respondent, who alone of the respondents appeared opposing this application for permission, that the second, third, and fourth grounds do not fall to be considered if the first ground does not disclose an arguable basis for appeal. That is on the basis that the inspector was entitled to reach and did not act unlawfully in reaching his conclusion that the proposed or actual change of use represented a danger of methane gas escaping and causing death or injury. If his decision on that point was not unlawful, then the challenge to his overall decision to dismiss the appeal could not be successful, however much it could be shown that he erred on grounds 2, 3, and 4. Against that, it was submitted on behalf of the claimant by Mr. Rudd, who appeared for him, that even if the first ground fails, and even if the effect of that is that the decision itself cannot be quashed, nonetheless, if there were errors on grounds 2, 3, and 4, the claimant was entitled to declarations to that effect, so that if on subsequent application for permission, such objections were to be raised, it could not be said that they had already been dealt with against him by the inspector. As it seems to me, the first respondent is right on that submission in that if the decision itself is not capable of being quashed by reason of ground 1, it would be an arid exercise to entertain by way of an appeal arguments that would be incapable of leading to a quashing of the decision under appeal, purely for the collateral benefit of arming the claimant with forensic arguments to preempt similar points that may be taken against him on a subsequent planning application. We refer to that, my lady, to say that, to make the submission that if the appellant fails on ground 1, that we would submit that the following grounds, the remaining grounds, have no utility and shouldn't be entertained.
Yes, thank you.
My lady, I don't know if you have before you, I had sent through 3 cases last week, Thursday,
Have
3
them.
cases. If I could just ask you to turn to the one tax commissioner against oleander cycles.
Yes.
And if you could go to paragraph 51.
Yes.
The court says, should the decision of the tribunal be quashed and or should the matter be remitted back to the tax commissioner for her to reconsider the objection? The answer to this question is a decisive no. The position would be otherwise if setting the decision of the tribunal aside and substituting the decision of this court on the new point of law alone would resolve the issue once and for all without any further factual inquiry. But the tribunal dealt with the appeal on its factual merits on the basis of the evidence placed before it, and with the assent of the appellant in an admirably sound manner. There is no basis for this court to conclude that it is likely, let alone probable, that the supporting information sought by the collector will be inconsistent with the sworn evidence of the taxpayer's witness, whom the tribunal found to be credible. This court cannot, on the basis of the sole ground of appeal which has succeeded, properly rule on the merits of the tax dispute at all. So this is a similar decision, my lady, where there were a number of grounds, one of which succeeded, but the court was of the view that where the others didn't, then what was the point of quashing the decision and sending it back when there's no basis on which to decide or to think that there will be a different outcome. So in our case, my lady, were you to find that the appellant fails on A, then what would be the point of sending it back simply on the basis of the others? If I could go to paragraph 18 of our submissions, my lady.
Yes.
We say in any event that there is no reasonable basis on which to determine that there is, as the appellant contends, a real concern that the minister failed to properly consider the matter. The unavoidable fact is that the minister's decision was made earlier when he signed his agreement with the planning inspector's recommendation. The recommendation was made on 2nd July 2019, and the minister's agreement was dated 11th July 2019. The minister clearly signified his agreement not just by checking the box, affixing his signature and time stamping it. He also wrote agree with inspector's recommendation and initialed this attestation. What we say here, my lady, is the contemporaneous documentation shows that the minister agrees with the inspector's recommendation. That's what he was agreeing with. What we have at tab 19, which is the letter from the minister, the tab 19 of the record.
Yes.
So this is a letter from the minister dated August 15, 2019. And this is where he's communicating the decision that the minister has made. And the second paragraph, you can see that it says, I have decided to support the inspector's recommendation and uphold the board's decision. Now we see where it says, and refuse the application for the following reasons. But we would submit, my lady, that that is actually simply him supporting the inspector's recommendation and setting out the board's decision. This is exactly how the board's decision was written, as my friend indicated last week. So this is not the minister deciding for the following reasons. He's already indicated that his decision is consistent with or that of the inspector's recommendation. This could easily, my lady, if you and obviously we have no evidence, and this is an appeal, my lady, based on what is before you. So it is not an intention to give evidence. But if that word "and" was replaced with "to," for example, it would show exactly what the minister clearly was intending to do, which is just recite what the board's decision was. And this, we say, my lady, is supported by what was actually written and done as it relates to the inspector's recommendation.
Right.
So what this seems to be, my lady, is, I will just leave it there, my lady. And I would just move on to, I think my friend may not have made submissions at the time, although he did allude to it in his written submissions on the issue of whether or not, if the court were minded to allow the appeal, whether or not it should be remitted for reconsideration, or whether or not a decision should be substituted. And I would just ask you to pull up those other two cases that I sent last week.
Yes.
Email, my lady. The first being the Bermuda Gas and Utility against the Tax Commission. You have, yes.
Yes, it's in front of me. Thank you.
Oh, I'm sorry. This is an appeal, similarly to where we are, my lady, an appeal on issues of law as it relates to findings by the tax commissioner. And if I could just ask you to go to firstly, page 6 of the decision.
Yes.
So just above paragraph 22, that line that says, "At first blush, this appears to be a fairly standard appellate jurisdiction, consistent with a high level of deference to the collector's primary fact finding and policy-making powers." And then, and this is not to go into detail in the merits, my lady, it's entirely a different set of facts. But at paragraph 33, the court accepted the submission that the appeal tribunal erred in law in deciding that it had jurisdictional competence to resolve issues which the collector had never determined, and then decided on the disposition of the appeal, my lady, if you go to paragraph 39, decided to remit the matter to the respondent for reconsideration according to law. And that's not unusual, my lady. If I could just ask you to look at the last case, Clark.
I mean, is it fair to say, is there any contention arising from the suggestion that that is the usual approach? The usual approach is to remit where there is a tribunal or any sort of statutory body where a point of law has been wrongly exercised, that it would be remitted. Is that controversial?
I believe it might be, I suppose,
Not controversial in the sense of what should I do now, but is it not accepted that that is the usual approach?
I think if I can help my lady, I think in this particular case, I think it would have to be remitted. I said something a bit different myself, an argument, but just think about more detail. I think it has to be, because it may well be that it gets, I put forward various grounds, and and it may well be that it has to be remitted, and then you've given a judgment that sets out what the correct legal position actually is, and then can be considered on that basis. But some of the grounds put forward concern areas where I'm not sure that you, as a judge, can really look at them, because it's for the people who have the policy position, who need to then reconsider in light of the correct legal principles instead of the incorrect ones that they did apply.
well, I'm happy for that clarification, my lady. So I won't need to go into the other case law.
I mean, I can tell you there are recent decisions. I know I've put out a few recent decisions on when the court will ordinarily remit a decision for a body of first instance, as opposed to usurping that function.
And there can be some circumstances where a legal point completely determines the whole issue.
Yeah.
So it determines whether you fall into this category or that category.
Yes, it's not
And if the
absolute,
answer, but if it's not an absolute like that, like this is not an absolute case. It's more, how do you apply policies in light of the legal principles? I think it has to be remitted.
Thank you, my lady. So in summary, really, my lady, we say that on the density issue, the minister was correct. The board was correct. The inspector's recommendation was correct. The minister was correct. And on that basis alone, that should be the end of the appeal. That the other grounds are a distraction, and that the evidence really shows what the minister's decision actually was, and that it was consistent with the inspector's recommendation, and that the appeal we submit should be dismissed.
Thank you very much, Ms. Sadler. That was helpful. Mr. Sanderson, you want to reply?
Yes, the only thing I'll say in my lady is regarding policy zone 9.1 of the plan. My friend says that suggests this is a policy which shows that you don't normally take into account the lot. But I would say it's actually the opposite. Zone 0.9, I say, supports my position, because what it's doing is it's saying that even when you have conservation land on a lot, that you will calculate it according to the total area of the lot, with the only provisos that it doesn't involve, the development doesn't interfere with the conservation zones. So zone 0.9, it says that it confirms that wherever it's feasible, the maximum density or the maximum site coverage shall be achieved on the basis of the total area of the lot. And then goes on to give the caveat, particularly with conservation, but in doing so, the board should be satisfied that all development is confined to development area beyond the boundaries of the conservation zones. It will not have a detrimental impact on the conservation zones, and it complies with the relevant development standards of the base zone, conservation zone, or conservation area. So I would say, my lady, that in this case, well, that it fully supports what's being done here, because in this application, the application submitted by Mr. Stirling does not interfere with any conservation zones, nor does it interfere with any rights of way, existing rights of way that form part of the lot. I don't think anything's been said that it has an impact on the rights of way, and it complies with the other development standards for the base residential zone. So I would just say that with regards to that particular policy, it doesn't point the way of the respondent, it points the way towards the appellant. And the other, sorry, just one other thing. My friend made reference to the suggestion that the parts of the policies, that the maximum site coverage.
Or shall I just hear you?
The maximum site coverage for this is in excess of that allowed by by RSD3. But that's, again, that's on her my friend's interpretation of what's meant by lot. on our interpretation of what is meant by lots, i.e., you look at the definition of what a lot is, it complies with the maximum site coverage. On my friend's definition, that she says that you have to look at lot size, not lot, then yes, it would be 29% instead of under 20%. But that's but as you heard me last week, my lady, these are very carefully defined words that are used throughout the definition has gone from many pages. And that also applies whether you look at maximum density definition or site coverage definition or maximum site coverage definition. They refer to lots, not lot size. Lot size has particular meaning for certain purposes, but not all purposes of the policies.
Let me just make sure I follow you on that last point, Mrs. Sanders.
Yeah.
You're saying in the context of RSD3 that when I'm looking at the maximum site coverage, I'm really concerned with the definition of lot as opposed to lot size.
Yes, you can go to definitions 106 and 107, I think it is.
I remember you took me to the definitions and showed me the difference, but
not these particular ones.
Yeah. Sorry?
Not these particular definitions, though. I was looking at the definition of lot size and lot and density, but my friend has raised the issue of site coverage, which is the percentage, and that's definitions 106 and 1.7.
Okay.
And again, it's with respect.
To lot you say and not lot size.
Exactly. It's page 210 of tab 5.
Yeah.
And again, it's referring to the area of a lot. That's the whole lot. That's not the part of the lot size. It's not referring to a part of the lot size. It's just the area of a lot, the whole lot. And that's whether you look at 106 or 1.7, site coverage and site coverage maximum. We're looking at lot here, not lot size.
I apologize for interjecting, my lady, but a similar situation with the definitions in the RSD3, in 106 and 107, it means the area of a lot which is covered or proposed to be covered by all buildings, et cetera, et cetera. So it still would have to be a determination as to what parts can be covered by buildings before we can say something like site coverage.
Well, RSD says it's 20%. RSD3 says 20%. It specifies for that particular one. Yeah.
Sorry, I am going to hear both of you on this point. So let me just hear what Ms. Savabes has to say, and then you can come back to that again, Mr. Sanderson.
Right, my lady. It really just boils down
to when you look under site coverage.
Yes, my lady.
And it talks about what's covered by all buildings. That can only be a reference to lot size.
That is what we're saying, madam.
Okay.
Using the same submissions earlier about why lot size is baked in.
Mm-hmm.
If it's related to lot size, then site coverage would also be related to lot size.
And Mr. Sanderson, your response?
Well, my response is that RSD3 itself sets out the percentages and the areas that can be covered. So the RSD is where you find that. And so apartment house, the minimum lot size must be 18,000 square feet. The minimum site coverage is 20%. The maximum density is 6 dwelling units per acre. Now, so then you turn to those definitions and you see what are they referring to. So for minimum lot size, it does actually, it's referring to lot size. So that is lot size, and Mr. Stirling's proposal complies with the definition of lot size. There's no issue there. It's Mr. Stirling's lot, the area of the lot which is being developable is more than 18,000 square feet. There's no dispute between anybody there with that one. The disputes that we have are in relation to the maximum density, which is 6 dwelling units per acre. And there, when you look at the definition of density, we say that you're looking at it refers to the lot, not a special portion of the lot. It's looking at the whole lot. And again, with respect to site coverage, It's site coverage of the lot as a whole. It's the whole lot, not part of the lot. So it's the lot, not lot size. Whereas for minimum lot size, it is lot size. It's
Right.
because these serve very different. They serve different purposes. Lot size is what is actually going to be developed. What can be developed on. It's quite different. It's to avoid people having like very small lots that are being crowded out. If you had a very small lot, you can't develop it. Is what that is the purpose of that minimum lot size. You have to have a lot size that's more than 18,000 square feet. Otherwise, you can't really develop it for RSD. You might be able to develop it for other things, but not under RSD3. And you have different lot sizes depending on what you want to do. So for an attached house, you can have a smaller lot size. For a detached house or an apartment house, you need a larger lot size. And in residential 1 zoning at RSD3, the minimum lot size is a lot smaller. So you can have much more crowded development in residential 1 than you can in residential 2. It's a higher density. You can have, well, when I say high density, you can have smaller lots. You can have smaller parcels next to each other. Whereas for residential 2, you're supposed to have larger parcels. But so Mr. Stirling has got his larger parcel of land. And then the question is, well, how many, so he complies with minimum lot size. He's got his large parcel of land. And then the second question is, well, how much the site can be covered of that large parcel? That's what maximum site coverage is with respect to. So they're different requirements. They raise different parts of what you can and can't do.
Right.
And normally, like we've looked at for conservation zoning, you look at the lot as a whole, even though you can't build on anything that's conservation, but you still get the benefits of your total lot area for the purposes of determining density. So Mr. Stirling is saying the same ought to apply to his lot as it applies to every other lot. He should get the benefits of the whole thing.
Thank you, Mr. Sanderson. I reserve judgment. I will deliver a written decision. I would usually produce that in a 6-week period. I cannot commit that will be the case here, although I certainly will endeavor to do so. But I have an extended remit, and so it is difficult for me to deliver judgments in the same usual time frame. But if that does prove to be the case, I will communicate that to you via the registrar.
Thank you, my lady.
Okay.
Thank you. Thank you very much. Have a good afternoon.
You as well, my lady.